How to make sure your money stays in your family. Hi, my name is Alec Oslin, and I'm an attorney at the Yanowitz Law Firm, where we've been assisting families with wills, trusts, and probate for over 3 decades. This is an issue that a large number of my clients have, and believe it or not, many people's estate plans open them up for the opportunity that would allow an in-law to potentially get all of the inheritance that they want to leave for their children. What do I mean by that? How exactly does that work, and why is that so prevalent in so many estate plans? Generally, when someone has a pretty simple estate plan, they're leaving their assets to their children outright with no restrictions. Just essentially, hey, I'm giving my assets to my children when I die, and pretty simple plan. Someone who is doing something like that is someone who has children who have a good head on their shoulders. They don't have any substance abuse issues. Children are older, not really 19 and 20 anymore. They're maybe in their 30s or 40s or 50s or older. And they have a type of plan that says, when I die, I leave everything to my son Bob outright and free of trust. That approach is simple and it gets the job done. However, with this type of simple distribution, we lose control. And what do I mean by that? In that situation, let's pretend that Bob is married. And so he gets this inheritance from mom or dad when they die, and then he dies a few years later. If he's married, he most likely is leaving all of his assets to a surviving spouse. And in that situation, there's nothing stopping that surviving spouse from getting remarried. So now your inheritance may actually be used for the benefit of not just a potential in-law, but some third party that in-law may marry. Sometimes an issue when we have a really simple plan is that the inheritance that you want to leave for your family may actually go for the benefit of some other third party who have no idea who it is. So how do we avoid that? What do we do? To avoid that, we set up a trust-based estate plan which restricts how assets pass. For example, following your death, we could have the assets be put into a trust and used for the health, education, maintenance, and support of your child. With that standard, health, education, maintenance, and support, specifically maintenance and support, really, really broad standards that allow the trust to be utilized for the benefit of your child. We can also have the child be the trustee of their own trust. So really they're in control and they're utilizing those funds in a way that's following the standard that you have set up. In that trust, we can have language of what happens if that child passes away. And we can draft the language in a way that states that the assets that are in this trust must be used for the benefit of the deceased child's children if they have any. So now these assets are going to be used for the benefit of your grandchildren. So it doesn't go to that in-law. Instead, essentially down through your bloodline. If you don't have grandchildren from that child, you can also draft it in a way that it goes to maybe their siblings or it can go to someone else. But the big thing here is that you get to pick who these assets are going to. That is one of the real big benefits here with a trust-based estate plan, is that you are in control of how these assets are going to pass regarding certain situations that may happen in the future. All of that being said, there's a number of other reasons why you still may want to have your beneficiaries inherit in a trust. However, setting up a trust-based estate plan can be a complicated process, which is why it's vital that you work with a firm who regularly drafts trust-based estate plans. With that, I'd like to thank you for watching the video today, and I hope you enjoyed it. Have a great day. Bye.